Good morning, everyone. Thank you for joining the Queensland Indigenous Family Violence Legal Service today. This is a pretty historic moment for us, given that this is the first time we've actually conducted a webinar over Zoom. Our normal way of practice is to actually deliver our community legal educations in person. But given the intervention of coronavirus and COVID-19, we've had to alter the way we conduct our business. So without further ado, I'd like to introduce you all to our presenter this morning, Ms. Natasha Priestly. Natasha is the solicitor team leader of my Central Queensland office based in Rockhampton. And Natasha will be taking you through the Magistrates Courts of Queensland and the impact of coronavirus, what you need to know. I believe with Zoom, and this is all new, so excuse me, you can actually post questions. We do have a question and answer segment at the very end, and we'll be responding to those questions. So please feel free to use the chat bot and send those through while Natasha takes you through. I hope you enjoy this presentation, and I'll hand over to Natasha now. Thanks, Natasha.
Thank you, Thelma. I've just turned on my video quickly just so you can put a face to the voice that you'll be hearing. And for anyone that I haven't met yet, I can see that there's a few participants from the Central Queensland region. So thanks for coming in this morning to hear the presentation. I'll stop the video now though, so you don't have to look at my face the whole time and you can concentrate on the slideshow. So this morning we are presenting a webinar on the Magistrates Court of Queensland and the impact of coronavirus. And to give everybody, our stakeholders in particular, a rundown of what you need to know and should keep in mind going forward. And I'll just confirm that I can work the slideshow. There we go. So just for a quick introduction on QIFVLS as an organisation, the acronym stands for Queensland Indigenous Family Violence Legal Service. And as you can see, we're a Queensland-based legal service. So we provide legal advice, legal representation, non-legal support, case management, and stakeholder engagement, as well as community education and community legal education. You can see that we've got offices in Brisbane, Rockhampton, Townsville, Cairns and Mount Isa, and each of those offices services their surrounding regions. Our head office is also located in Cairns. In particular, the Rockhampton office, you can see the areas that we service around town. Due to COVID-19, we haven't been able to go out to those regions, but are still connecting with them by phone. And most of our offices are doing the same to try and support those regions. In terms of, sorry, I'll just go back to the previous slide. In terms of our practice areas, we work in predominantly domestic violence, child protection and family law. We also do some minor civil matters such as victims assist applications and some QCAT appearances if necessary. And that's why specifically today we're giving a presentation on the Magistrates Court response to the COVID-19.
Sorry, Tash, it's something, my apologies everyone, that I forgot to do at the very beginning, and it's something that we always do. Excuse the nerves, but I'd like to show my respect, as well as Natasha and other members from QIFVLS today, pay my respects and to acknowledge the traditional custodians of the land we're meeting on today across the various parts of Queensland. I'd like to pay my respect to their elders, past, present and emerging, and pay my respect to all Aboriginal Torres Strait Islander people who may be joining us today. Thank you. Sorry, Tash.
Thank you, Thelma. No, that's okay. So in terms of the Magistrates Court and their response to the coronavirus or COVID-19 issues, to ensure that the essential services provided by the Magistrates Court across Queensland continue to be provided, the Magistrates Courts have introduced measures to permit the courts to continue to operate whilst operating consistent with the health advice and social distancing measures introduced to minimise the spread of COVID-19. So in terms of what does that mean, are the magistrates courts still running? The answer to that is yes, they are still running, but they're doing so in a different way during this period. All matters at this stage are being conducted by telephone or video link facility, including for both adults and juveniles who are in custody or detention. And my personal experience in the Central Queensland region is that everything has been running by phone. We haven't had the pleasure yet of having any video link hookups for the court appearances, but I do know the courts are very keen to explore that as an option if they can do it. Physical appearances are allowed, but only in the following circumstances. If it is an aggrieved person who is self-represented in an urgent non-police private application for a domestic violence protection order, so that means that the victim representing themselves is appearing at the court to make an application on their own behalf. Or where the Magistrates Court gives permission for a matter to proceed on the basis of physical appearances. And that can be both for the clients and the solicitors. If there are special circumstances, you can apply to the Magistrates Court to appear in person. And I believe they just take that on a case-by-case basis at this stage as to whether or not you do have reasons to be in there in person. And physical appearances are allowed by the media. So in terms of the types of matters that the Magistrates Court are hearing during this period, they're still continuing to hear overnight custody arrests for both children and adults, urgent domestic violence order applications, also known as DVOs, including applications to vary a DVO. So it's not just limited to the initial application, but if the DVO needs to be varied in any way, those applications will also be heard. Urgent child protection order applications, including applications to vary existing orders, bail applications and applications to vary the conditions of bail, DVO applications currently before the court. Now this is for matters that have not already been considered, but which have now become urgent because of certain circumstances, and the Magistrates Court can be satisfied that any further delay would cause prejudice to a party. And this could be in circumstances where an application has been made. The court may have found that the application was not properly served and the respondent hasn't been put on notice. They've perhaps adjourned the proceedings off, waiting for confirmation of service. There may have been not immediate grounds for concern to warrant a temporary protection order being made, but as that delay has gone on, those circumstances have become more urgent, and so then they will proceed with hearing that application. Sentences, including lengthy sentences where a person, adult or child, on remand or in detention is likely to be released from custody. Committal callovers and summary hearing callovers, where a defendant is in custody or detention, and that's for either an adult or a child. Any urgent regional or Queensland Civil and Administrative Tribunal matters, that's the QCAT matters. Applications under the Police Powers and Responsibilities Act 2000. Civil matters to be dealt with on the papers. And so that is a change from hearing them in person, where perhaps lawyers or parties would provide oral submissions. The court may accept written submissions and then will determine the matter based on those written submissions. And other matters where the Magistrates Court has granted permission, especially where that matter is urgent and the Magistrates Court can be satisfied that delay in further hearing the matter will cause substantial prejudice to a party. And then the bottom note there is just that in relation to urgent domestic violence order applications, this includes those brought by the police on behalf of the aggrieved, a lawyer on behalf of the aggrieved, or a self-represented aggrieved person. And so again, regardless of who is making that application, it will be considered and deemed whether it's urgent or not. So why is it so important to keep awareness alive in our communities about domestic and family violence, and especially during this COVID-19 period? We like to keep awareness about the public health measures put in place to stop the community spread of the virus. These public health measures and responses have focused on public hygiene and social distancing, including working remotely where possible to do so. And in that regard, I can confirm that as soon as we were able to, the QIFVLS organisation did move to remote working. The offices have been closed to the staff and the public. We all have been adopting a work from home model, which in most part has been very successful. We also want to keep awareness going of domestic and family violence. It's more than just physical injuries and bruising, and includes coercive and controlling behaviours. It's important to be reminded of a number of key aspects of the impact of domestic and family violence in our communities, as demonstrated in the following infographics. And you can see there that we've adopted a small infographic from the Australian government in relation to family, domestic and sexual violence and the impacts that it has. You can see some of the key figures there that are raised, especially in relation to domestic violence being a greatest health risk factor for women aged 25 to 44. It's a greater health risk factor than smoking, alcohol or physical inactivity. And then the other big one there is the number of people that sought help. So 72,000 women, 34,000 children and 9,000 men sought help for homelessness due to family violence in 2016-17. In terms of information about domestic violence and the impact it has on our communities, this is what we know. Children of mothers experiencing domestic violence have higher rates of social and emotional problems than other children. Domestic and family violence is the leading cause of homelessness for women and their children, and that was demonstrated by that previous graph, as mentioned, the number of people seeking assistance for homelessness. Intimate partner violence is a leading contributor to illness, disability and premature death for women aged 18 to 44. Most women leaving a violent relationship move out of their home, and Indigenous women are 32 times more likely to be hospitalised due to family violence than non-Indigenous women. In terms of what is considered family and domestic violence in Queensland, physical or sexually abusive behaviour, emotional or psychologically abusive behaviour, economically abusive behaviour, threatening or coercive behaviour, or behaviour which in any other way controls or dominates the second person and causes the second person to fear for the second person's safety or well-being, or that of someone else, their child, for example. So, what will the Magistrates Court consider in granting a domestic violence protection order? There are 5 different considerations for the court. The first is that there's a relevant relationship. Now that can be broken down again in looking at whether there's a family relationship, whether it's a domestic as in a spousal or marriage relationship, or whether it is a parent-child relationship. There are some other definitions, which is why it's important to get legal advice about whether you meet that criteria. The second is that there has to have been an act of domestic violence committed. Now, we just went through the list of incidents which would be considered domestic and family violence. That list is not exhaustive that we just presented on. There is a long list of what could be considered domestic and family violence. So again, it would be important to get some legal advice if you're unsure if what's happened to you would be considered domestic violence. The third consideration is whether the protection order is necessary or desirable. And that is just for the court to consider whether this order needs to be made to protect the person seeking that the order be made. The court then needs to consider whether a temporary protection order should be made. Now, the circumstances for that to occur could be where an application has been made and the respondent has not been served, but the aggrieved is in immediate danger, or there are some other circumstances where behaviours have been occurring which require the aggrieved's immediate protection. In those circumstances, the court may consider putting in place a temporary protection order. and that temporary protection order can be in the same terms as you're seeking on a final basis. Another reason a temporary protection order may be made is if the aggrieved is seeking an order and the respondent opposes that application. It may still be necessary for the aggrieved to have some protection until that application can be determined on a final basis. And finally, that's where the court determines whether that temporary protection order is necessary or desirable. So, given the current circumstances, has the process for applying for a DVO in a private application changed since COVID-19? So in terms of a private application, again, that's where the aggrieved or the victim is making that application themselves. So yes, the process has changed. Before COVID-19, the process was for the aggrieved to complete a DVO application form. They would then sign the form and have that witnessed by a lawyer or a justice of the peace. They would then file that application with the court, at which time it would be listed. Now, courts had different listing times. In Rockhampton, it would be listed 7 days later, unless there was any grounds for urgency, and then it could be listed the next day. The process now, during the COVID-19 restriction, is that the DVO application is completed by the aggrieved and emailed to the court registry. The magistrate will then consider the application and consider that it meets those criteria that we previously discussed. The magistrate will then contact the aggrieved by phone. The aggrieved will then complete another form if required by the court. Over the phone with the magistrate, the aggrieved will then give a declaration that their evidence is true and correct. The court will then accept that application and the registry will file it electronically. After it's filed, it will then be sent out to the police to be served. And if the court deems it necessary or desirable, a temporary protection order may be made at that point. And following on from that, it will be given another court listing. And that's where the DVO and TPO copies are provided to the respondent, and the aggrieved will also get a copy, and the further court orders will be, further court dates will be allocated. So what is happening with currently listed matters in the Magistrates Court before the COVID-19 issue? So this is in terms of matters that were already on foot, and then we had the COVID-19 restrictions implemented, and this is how the court has been approaching those matters. So in terms of all matters before the Magistrates Court, the general consensus is that they're being adjourned off to another date, so criminal law and civil law matters. The parties are sent a notice of the adjournment. It should be emailed or posted to the lawyer or direct to the self-representing party. Bail has been enlarged. If a defendant has bail in a criminal law matter, bail was enlarged to the new adjournment date in the absence of the defendant. Temporary protection orders continue. So in domestic and family violence proceedings that commenced prior to COVID-19, any temporary protection order made at that period has been automatically continued on for the period of the adjournment. So for example, I have a matter where we had a first return date prior to the COVID-19 restrictions. A temporary protection order was made. The application was opposed by the respondent. It was set down for hearing. That hearing date was to occur in June and was automatically adjourned due to the COVID-19 response. We then got a notice of the adjournment and a notice that the temporary protection order was to continue in that period. And in terms of prejudice to the parties, as the court had already determined the temporary protection order was necessary, there was no prejudice to the parties in that continuing for that period. We are still awaiting a new trial date. So what about regional and remote Magistrates Court matters and what is happening with these matters? So in line with the other courts, physical attendance has been suspended, and that was from the 30th of March 2020. The circuit court circuits are continuing via phone and video link. So the magistrates courts are continuing to hear matters that are listed using telephone or video link facilities from the home court. So speaking of my experience in Central Queensland, the circuit courts are operating from the Rockhampton Magistrates Court or from the Gladstone Magistrates Court. And for example, the Rockhampton Magistrates Court is running the Billawheeler Magistrates Court appearances from Rockhampton. Circuit Court's recommencement is unknown. So as to when the Magistrates Courts will recommence travel to sit in those circuit courts, no date has been provided. It's going to depend on a number of factors, including when regional and/or remote communities reopen, given a number of regional and remote communities in Queensland have closed access to those communities. And it's also going to depend on the medical directives provided by the Commonwealth and State of Queensland in relation to permitting travel extended distances. So there's currently restrictions on how far we can travel. Those are slowly increasing, but that's going to determine when these circuits can recommence. So what if you or a client you're working with has an urgent matter and you need to get listed in the Magistrates Court? So as discussed, the Magistrates Courts continue to operate. Urgent email applications are being accepted, and we went through that process of the applicant or their representative sending through that application. What do I do if I think that the matter is urgent? So as discussed previously, it's at the court's discretion effectively as to whether or not the matter is urgent. That application can be emailed to the court for the magistrate to consider. In emailing the application to the court, that is where you would seek an urgent listing or an urgent consideration of the application. The magistrate, depending on the evidence provided in the application, would then make contact to discuss that application with you. That's when the magistrate would then consider whether it needs to be urgently listed. And that last point states to prevent prejudice. So, and that's in terms of to the applying party and to the respondent. Does the matter need to be dealt with urgently? If there are any delays, will one of the parties be prejudiced because of those delays? So those are the factors that will be considered when thinking about whether it's an urgent application or not. But we would probably advise our clients that if you consider that you need an application to be made and you need that domestic violence order for your own protection, that there's never any harm in contacting the court about that to seek an urgent listing. So can QIFVLS still help me during the COVID-19 response? The very, very emphatic answer to that is yes. So whilst QIFVLS, like many other services, have ceased face-to-face contact due to COVID-19, we are still here working remotely and speaking to clients and communities on the telephone or by video conference meetings. QIFVLS continues to provide services to our clients in the areas of domestic and family violence, child protection, family law, victims assist applications, support in relation to sexual assault matters, and we are also providing community education sessions and community legal education sessions, though over the phone or by video link. In terms of contacting QIFVLS, we are open during the hours of Monday to Thursday, 8:30 till 5, and Friday, 8:30 till 4. We have our statewide contact number and our statewide email address. If you have been connected with a regional centre for QIFVLS, you also may have been provided a referral process, and those are still up and operating. You can also contact the various offices direct. So that brings us to the end of the slideshow presentation. We'd like to open it up for any questions, or if there was anything that we maybe didn't cover off on and there's any comments that would like to be made, please feel free to let us know.
Thanks, Natasha, for the presentation. I think I'd like to just add in there, and for people who don't know me, my name's Thelma Schwartz. I'm the Principal Legal Officer of QIFVLS, and obviously the nerves have got to me with the first presentation. I've got a bit of stage fright and forgot to introduce myself, but I'll learn from that. What I'd like to know is one of the reasons why we've pulled together this webinar, other than it being a first for us in this capacity, is really looking at and reminding people about why it's so important to discuss domestic and family violence, given that we know from the stats and the various research out there that people who are going through or experiencing domestic and family violence already feel isolated and cut off from others. And COVID-19 has really brought that to bear, that sense of isolation and feeling cut off. And obviously wanting our communities to be aware that when things did close down and we had to resort, like many other businesses throughout Queensland, to working remotely, that we are still here and able to give assistance and support, and that courts are still functioning, because I know that there have been perceptions that have been coming through from various people we speak to that courts and other agencies have stopped. Police have been focusing really on COVID-19 responses as their primary focus and not really looking at the health and well-being of people, especially if they're in domestic and family violence situations. So that explains why we've spent a lot of time developing this webinar, as well as there was a fact sheet that was also developed and shared with our communities and stakeholders. So I hope that gives you all a bit of a context as to why we've done what we've done, and keeping it very alive. So I might just see if there's any other questions. I haven't got any Zoom webinar chat questions. I'm just checking my chat box. See, we have a question here from Nicholas Pagonis. And the question is, has the process for respondents to respond to DVOs changed in light of the current circumstances? Natasha, can I hand that over to you?
Absolutely. So just to clarify, so the question was whether the process for respondents has changed? So in terms of being a respondent in the proceedings, the process has only changed in that the respondent is now required to contact the court to seek to confirm their attendance and appearance at the proceedings. The respondents are being accepted in person if they are unsure how to attend otherwise. So the court has been releasing some information to both aggrieved and respondents, encouraging them to provide a contact number for their matter so they can also appear by phone. I know that the experience in Rockhampton is usually that we have domestic violence support workers and duty lawyers at the court who can assist respondents on the day. Most of those services, and I think in Rockhampton in particular, all of those services have now ceased. Duty lawyers are now doing over the phone duty advice, and the DV support workers are not at the court. I do know that for the respondents, one of the issues that we are working through at the moment is getting access to the duty lawyer. The usual process is that you would attend, register that you've attended for your matter. You would then be directed to the duty lawyer if you wanted to get some advice, and that duty lawyer would be assisting you before your appearance. The feedback I've had from the community in the central Queensland area is that what's actually been happening is the respondents have been attending a court, have been doing their appearance and seeking adjournments to get advice, and they've then been directed to contact the duty lawyer to get advice after the matter. So it is causing a little bit of delay, but the same services are all available for respondents. And I guess they are eventually being directed to the right services to get that advice and assistance. albeit it's causing some delays in adjournments in the matters. If a respondent does turn up and hasn't had any advice and would like to seek advice, the magistrates will allow that to happen, and they will adjourn the matter for the respondent to get that advice. So I guess in summary, there have been some changes for the respondent, but if they are going to turn up to the court for their matter, they will be directed to the appropriate services to assist them.
Thank you. I see that we've had a couple of questions around the PowerPoint availability. Yes, that will be made available to all attendees, so that can be forwarded. I hope that answers your questions on that point. I think the other observation that I'd like to put out here at the moment, obviously our concern at the moment being regional remote, we spend a lot of time in regional remote Queensland, is with the courts conducting circuit courts out of home courts, and obviously the bulk adjournments not only of circuit court matters but regional court matters. When the lights actually turn back on, communities come back online, Queensland opens up again. You've all seen what's happening in the media with other states and territories agitating to reopen travel and so forth. The concern is with all of these bulk adjournments in our magistrates courts across the board, what happens when we come back online? And we need to then start servicing not only regional courts, but our rural and remote communities. So we're anticipating that there will be a backlog of matters going through the courts. What we've seen so far is the focus really on matters that are in custody, whether you're an adult or a juvenile, and matters that are not matters that are deemed to be urgent are taking priority. But you know, this is where we anticipate that there will be some issues arising, and QIFVLS has actually been very vocal in this space, most recently with a meeting with our Minister White, expressing our concerns about how the backlog will be managed not only in our state courts but also in the federal circuit courts, who've also gone through a very similar situation in relation to how they've dealt with and case managed family law matters, and you know what the likely response will be in that court. So I think at that juncture I might just let you know that we are presenting another webinar session this Thursday in relation to the Federal Circuit Court and the family law response. So just keep an eye out if you're interested in having a look at that.
Okay, well, it seems like there are no other questions coming through. So thank you everyone for attending today. It was great to have you all on board and participating with us for our first webinar. I hope to see you all on Thursday for the next one. Thanks everyone.
Thanks everyone.
Thank you.